6 words. That's all it took. Not a subpoena, not a leaked classified document pulled from a sealed reading room somewhere beneath the Hart Senate office building. Not a whistleblower's sworn affidavit or a grand jury transcript or a wire transfer confirmation with somebody's name circled in red ink. 6 words delivered in a voice so controlled, so precisely calibrated to the frequency of institutional danger that the entire hearing room underwent a physical transformation in the space between the question being asked and the answer failing to arrive. "You were there, weren't you?" Pam Bondi blinked. 1 beat, 2 beats, and in those 2 beats, those 2 measurable, camera-recorded, permanently archived seconds of unbroken silence from the Attorney General of the United States, Congresswoman Jasmine Crockett accomplished something that no subpoena, no document release, no procedural motion filed inside the administrative machinery of the Department of Justice had managed to accomplish in years of carefully managed institutional distance. She made the silence speak, and what it said was louder than anything Bondi offered in the 40 minutes that followed. This is the hearing Washington built a firewall around. This is the exchange that was supposed to be buried under procedural noise, drowned out by partisan crosstalk, diluted into the standard congressional theater of aggressive questions and managed non-answers that produces heat without light and clips without consequence. It didn't stay buried. Because Jasmine Crockett didn't come into that room to perform. She came in loaded. Understanding what Crockett did in that hearing room requires understanding what she didn't do. She didn't arrive with theatrical fury. She didn't open with the kind of bombastic accusation designed to generate a 30-second clip that circulates for 48 hours before the news cycle swallows it whole. She didn't bang the table or raise her voice or deploy the standard congressional toolkit of performative outrage that witnesses have been trained to weather for decades. She arrived with a manila folder, a calm voice, and a straight posture that veteran Capitol Hill observers recognize immediately as the physical signature of someone who built the trap long before the cameras turned on. Bondi, sitting at the witness table with the polished composure of a woman who had successfully navigated harder rooms than this one, registered none of it as threatening. Her team had prepared her for aggressive questioners. Her talking points were memorized. Her deflection architecture was fully operational. For the first portion of the hearing, she had moved through questions with practiced ease, confirming statistics, correcting the record where she could, offering appropriate assurances in the measured cadence of an official who has been thoroughly briefed and has absolutely nothing to fear. She looked, in those first minutes, like a woman who intended to walk out of that chamber with her composure exactly as intact as when she walked in. Crockett understood that. It was the entire strategy, because the most effective congressional traps are never sprung at the beginning. They are constructed across time, question by question, layer by layer, each exchange apparently reasonable, each answer apparently safe, until the accumulated weight of the architecture reveals itself, and the exit routes have already been quietly sealed. Crockett opened on apparently solid ground. "You stated in your written testimony," she began, her voice low and precisely controlled, carrying the particular authority of someone who has read every word of every document submitted to this committee and is now simply giving the witness an opportunity to confirm what they already said. "That when you took office, you had 2 main goals. The first was to end the weaponization of justice. The second was to return the department to its core mission." Bondi nodded, fast, almost reflexively, the nod of a witness who recognizes friendly terrain and moves toward it instinctively. It was the last moment of comfort she would experience in that room. "Not only have you failed to deliver on both," Crockett continued, her cadence sharpening with the precision of a blade finding the exact angle of entry, "the evidence suggests you've done the exact opposite." The room tightened before anyone processed the words consciously. It was physical before it was intellectual, the atmospheric compression that happens when a question moves from procedural into something that carries real structural weight. Crockett didn't pause to let Bondi respond. She kept stacking, detail by detail, dropped cases, investigations quietly closed inside the administrative state's vast machinery of discretionary inaction, each shut down leaving no formal record, no press statement, no accountability trail that oversight could follow. And with each line, Bondi's expression underwent a subtle but visible recalibration, from prepared confidence to something that looked increasingly like the controlled management of annoyance at being forced to absorb this kind of scrutiny on camera. Then Crockett turned the hearing toward the angle that made the room go cold. "Let me talk about what your department is not doing." The phrasing was deliberate, not what the DOJ had done wrong, not what Bondi had failed to pursue. What it was not doing: present tense, ongoing, active, a state of institutional paralysis that was not historical but current, not concluded but continuing. "Because there is a mountain of documentation," Crockett said, and the phrase landed with the particular weight of an understatement deployed by someone who understands that clinical language hits harder than inflammatory language in a room full of officials trained to dismiss inflammatory language on contact. 38,000 references across more than 5,000 files connecting high-profile individuals to Jeffrey Epstein's network of unethical and serious misconduct. She let that number sit in the room for a moment. 38,000 references, 5,000 files. Not allegations assembled from anonymous sources, not forum speculation or investigative journalism extrapolations. Documented references inside federal files, the same files that the DOJ itself had released, the same files that formed the evidentiary backbone of one of the most consequential accountability processes in modern American history. "And your department has produced nothing," Crockett continued, her voice carrying no theatrical inflation, just the flat, inexorable momentum of documented fact. No clear accountability established, zero new prosecutorial action against the individuals named in those files. The press gallery went still, cameras locked on Bondi's face. And this was the moment, captured on every recording device in that chamber, when Bondi stopped looking like an attorney general, confidently managing a difficult hearing, and started looking like something else entirely. Something more uncomfortable, something that the body betrays before the mind can construct the appropriate institutional language to cover it. She stopped looking prepared. She started looking cornered. Crockett saw it. Of course she saw it. She had been watching for exactly that recalibration, had been building toward exactly that visible shift from the first question she asked, because the real target of the trap was never the answer Bondi would give. It was the reaction Bondi would be unable to fully control when the question she was least prepared for finally arrived. And now Crockett moved toward it. "Let's stop dancing around it." 3 words that functioned as a formal notification to everyone in that chamber that the procedural portion of the hearing had concluded and something more dangerous had begun. Crockett leaned forward. The physical geometry of the moment shifted, the angle of engagement narrowing, the distance between questioner and witness collapsing in the way it does when a conversation stops being about policy and starts being about something that one of the participants would have given almost anything to keep out of that room. Who had jail access? Who approved that access? And why does the public still have no straight answer? She opened the folder in front of her. Because the DOJ's own Inspector General issued documented findings describing what it called serious negligence and multiple systemic failures in how the Bureau of Prisons handled the Epstein matter. Failures that occurred under the direct institutional chain of command of the Department of Justice. This was the forensic foundation that separated Crockett's strategy from every previous attempt to force accountability on this question. She wasn't operating in the realm of speculation or inference. She was standing on a documented IG report, the government's own internal oversight mechanism producing its own internal verdict of serious negligence and systemic failure, and asking the official who sat at the top of the chain of command responsible for those failures to explain what she knew, when she knew it, and what action she took. "I have to ask you," Crockett continued, her voice carrying the particular steadiness of someone who has prepared for this moment across weeks of document review and is now simply reading the conclusion into the permanent record, "because the American people deserve to know whether senior figures within that chain of command were aware of the conditions surrounding Epstein's custody in the period before his death, whether they had been briefed, whether anyone with institutional authority exercised that authority in ways that have never been publicly accounted for." The room was completely silent, the kind of silence that has texture, that presses against the walls and settles into the corners and makes every person present acutely aware of their own breathing. Crockett stopped cleaning it up for the room. She looked directly at Bondi, and she asked it. You were there, weren't you? What happened next lasted approximately 2 seconds in real time. In political terms, it lasted considerably longer. Bondi blinked. Her lips pressed together, not the natural compression of someone gathering their thoughts, but the tighter, more deliberate compression of someone selecting from a very small number of available options and finding none of them clean. Her eyes moved, briefly, downward, a micro-expression that analysts and body language specialists would spend days dissecting in the aftermath. The involuntary visual retreat of a person whose internal processing has been temporarily overwhelmed by the structural weight of a question arriving from a direction that wasn't fully anticipated. For one split second, one camera captured, permanently archived, endlessly replayable split second, the most powerful law enforcement official in the United States looked like someone who had just heard the one question she had been hoping, across the entire architecture of this hearing, would never be asked in exactly that form. Not a long pause. 2 seconds. But in a room where 200 people had stopped breathing simultaneously, 2 seconds carries the informational density of an entire testimony. Because that kind of delay, that specific variety of non-response from a prepared witness who has successfully managed hours of aggressive questioning, doesn't happen when someone feels fully in control of the room. It doesn't happen when the question is anticipated and the answer is ready and the deflection architecture is fully operational. It happens when something lands too close. When a question touches the exact subject that the DOJ, the Bureau of Prisons, and the institutional machinery surrounding the most controversial custody death in modern American history had spent years carefully constructing language to avoid touching directly. Crockett didn't move, didn't press, didn't fill the silence with elaboration or follow-up, or the kind of aggressive redirection that would have given Bondi something to push back against. She simply waited. And the waiting was the most devastating prosecutorial move available to her, because it forced Bondi to fill the silence herself. And what Bondi filled it with, the language she reached for in those 2 seconds and everything that followed, told the room something that no document, no IG finding, no 38,000 file references had managed to say with equal clarity. When Bondi finally spoke, it sounded polished. That was the first problem. Because polished in this context, in the specific context of a question about documented systemic failures surrounding a high-profile federal custody death, asked directly to the official who sat at the top of the institutional chain of command responsible for those failures. Polished sounded wrong. It sounded rehearsed in the particular way that matters most on camera, the way that signals to every viewer watching that what they are receiving is not transparency, but management. She went straight into system language, layers, procedures, structures. The vocabulary of institutional complexity deployed not to illuminate, but to obscure, to create around a simple, direct question such an elaborate architecture of administrative context that the question itself gets lost somewhere inside it, buried under the procedural weight of how complicated it all is, and how many moving parts were involved, and how unfair it is to reduce a systemic failure to a single accountability question directed at a single official. Crockett barely interrupted. She didn't need to. Because Bondi was already making the problem worse. With every sentence of system language, every reference to layers and procedures and oversight mechanisms and institutional complexity, she was demonstrating in real time exactly what Crockett had come to demonstrate. That the top law enforcement official in the country, when confronted with documented evidence of catastrophic oversight failure under her institutional chain of command, defaulted to explaining how complicated the system was, rather than saying what she knew, when she knew it, and what action she took. And then came the detail that transformed the response from inadequate into something more revealing. She moved away from the word access, quickly, almost imperceptibly, but not imperceptibly enough for a room that had been watching for exactly this signal. No clarification, no timeline, no direct denial constructed with the specificity that an innocent official with nothing to hide would deploy automatically. Just distance, the particular institutional distance of someone trying to ensure that a word once introduced into the room doesn't attach itself to their name in the permanent record. You have prioritized avoidance over transparency, Crockett said in her closing statement, and the sentence landed not as political accusation but as forensic summary, a description of what the room had just witnessed in real time, delivered with the calm precision of someone who had watched exactly this pattern play out across exactly this hearing and was now simply naming it for the record. Systemic failure over accountability, and political loyalty over constitutional obligation. Bondi attempted to turn the room. New cases, new accusations, new talking points, imported from entirely different contexts, deployed with the practiced efficiency of an official who understands that the fastest way out of a dangerous subject is to introduce a competing subject and hope the room follows. It was, by that point, transparently obvious what she was doing, moving away from the one thing she did not want sitting at the center of the hearing. And in moving away from it so visibly, so deliberately, she placed it there permanently. Here is what makes the access question more than political theater. Here is why it survives every attempt to contain it inside the language of partisan confrontation and emerges each time as something harder and more structurally serious than any single hearing can fully absorb. The Bureau of Prisons' failures surrounding Epstein's custody were not minor administrative errors that fell within the acceptable margin of institutional imperfection. They were not the kind of procedural lapses that IG reports document routinely and that institutional review processes correct through standard accountability mechanisms. They were documented as severe. Cameras malfunctioned on the night in question. Required monitoring protocols were not just bent, but skipped entirely, not once, not through a single lapse in judgment, but through a pattern of non-compliance that investigators found impossible to attribute to coincidence alone. A high-profile individual who had been previously flagged for elevated monitoring requirements, flagged specifically because of a prior incident that should have placed him under the most stringent available supervision, was left unmonitored during the critical window. Guards later admitted to falsifying monitoring records, not misremembering, not making administrative errors in documentation, falsifying. These are not allegations. These are documented Inspector General findings. The government's own internal accountability mechanism, applying its own evidentiary standards to its own institutional conduct and producing its own verdict, serious negligence, multiple systemic failures. A pattern of non-compliance that defied the standard explanations available to institutions defending themselves against oversight. And here is the gap that Crockett was pressing on, the oversight loophole that exists not in any statute, but in the space between what the IG documented and what the chain of command above the Bureau of Prisons has ever been formally required to explain. Federal detention facilities like the Metropolitan Correctional Center don't operate on the honor system. They operate on layered documentation requirements, entry logs, visitor records, access authorizations, chain of custody protocols, precisely because the people held inside them are, by definition, in the custody of the United States government, and the government has both a legal and constitutional obligation to account for what happens to them. Every entry to a high-profile federal detainees' housing area is logged. Every visitor is documented. Every access authorization leaves an institutional trace, which means that the documented failures surrounding Epstein's custody, the malfunctioning cameras, the skipped monitoring protocols, the falsified records, didn't happen in an administrative vacuum. They happened inside a system that was generating documentation at every level. And somewhere inside that documentation, there are answers to the questions that no official in Bondi's position has ever been required to answer directly. Who had access? Who approved that access? Who was briefed on the conditions of his custody in the period leading up to August 10th, 2019? And whether anyone with institutional authority that runs directly through the chain of command of the Department of Justice, exercised that authority in ways that the public record has been carefully, deliberately, institutionally constructed to leave unexamined. That is the question Crockett threw into the center of the room. That is the question Bondi's system language, her procedural deflections, her visible pivot away from the word access, failed to answer. And that gap, that carefully maintained, institutionally protected, years-in-the-making gap between documented failure and assigned accountability, is precisely why the clip kept spreading long after the hearing ended. Bondi is gone from that office now. The hearing ended, the cameras disengaged, the press gallery filed out, carrying their recordings and their notes and their clips. The official machinery of Washington moved on to the next procedural event on the calendar, as it always does, as it is designed to do, generating enough forward momentum that the questions left behind any single hearing get buried under the weight of whatever comes next. But the questions Crockett put on the record didn't leave with Bondi. They don't work that way. Because once a question is asked in a setting where the silence that follows it becomes part of the permanent congressional record, it acquires a kind of institutional immortality that no press statement, no administrative transition, no carefully managed successor appointment can neutralize. It lives in the transcript. It lives in the archived footage. It lives in the documented gap between what was asked and what was answered, a gap that every future official who sits in that witness chair will be required to account for, whether they prepared for it or not. Was there access that hasn't been publicly accounted for, not proven, not documented in any form that the existing evidentiary record can confirm, but not put to rest either? And in Washington, questions that aren't put to rest don't stay contained. They travel. They move through legal circles and intelligence briefings and investigative newsrooms and oversight committee research files. They attach themselves to subsequent hearings, subsequent witnesses, subsequent officials who find themselves sitting in the same chair Bondi occupied and facing a version of the same question Crockett asked, because the documented IG failures didn't disappear when Bondi left the office. The 38,000 file references didn't become less significant. The access question didn't become less structurally serious simply because the official best positioned to answer it chose, in that hearing room, to deploy system language and institutional distance instead. Crockett's strategy was never about forcing a confession in real time. Confessions don't happen in congressional hearings. The administrative state didn't build itself over decades into the most institutionally resilient bureaucratic structure in democratic history by producing confessions under camera pressure. What Crockett was doing, what she accomplished with 6 words and 2 seconds of silence, was something more durable and ultimately more dangerous to the institutions she was examining. She isolated a reaction. She built pressure across 40 minutes of methodical, forensically grounded questioning, layer by layer, until the official she was questioning stopped responding, like someone delivering prepared testimony, and started responding, like someone trying to avoid a collision with a subject that had been kept carefully out of the formal record for years. And then she named it, on camera, under oath, in the permanent congressional record of the United States. Here is the final image this hearing left behind. Not a document, not a dramatic confrontation, not the kind of smoking gun moment that Washington occasionally produces and immediately works to contain. A 2-second pause, a blink, a jaw pressing together with visible effort. And an Attorney General of the United States, a woman with 115,000 employees, a $40 billion budget, and the full institutional weight of the most powerful law enforcement apparatus on Earth behind her, looking for 2 measurable, camera-recorded, permanently archived seconds, like someone who had just heard the one question she was never supposed to be asked in public. You were there, weren't you? The answer that followed was polished, careful, institutionally constructed to create maximum distance from the subject while maintaining the surface appearance of engagement. It was, in the precise forensic vocabulary of congressional oversight, not an answer at all, and Jasmine Crockett knew it. The room knew it. The cameras knew it. And somewhere beyond the procedural machinery of a hearing that officially concluded when the gavel came down, the question is still sitting exactly where Crockett placed it, in the one location that the administrative state's formidable apparatus for managing uncomfortable truths cannot reach: the public record, where it will wait for as long as it takes.